Good afternoon, everyone. I'm Robert Nogacki, Kancelaria Prawna Skarbiec, law firm from Warsaw. Welcome to our webinar concerning U.S. company formation. I'm honored to be joined by Michael Tryson, who is partner in Cullen and Dykman, which is an American law firm. Michael is attorney with over 30 years of experience in advising international clients with great experience also on Polish market. Michael, welcome.
Thank you. Good morning.
I hope that soon we're gonna be joined also by Bożena Diaz, who is a partner in Cullen and Dykman, is focused on in tax planning, on corporate law, and guiding foreign investors who want to join. Let's say enter American market. Is Bożena with us already? Welcome,
yes,
Bożena.
she is. Yes.
Okay, welcome, Bożena.
Good morning.
Hello, nice to hear you. During the webinar, I will serve as a moderator, posing some questions from Polish perspective, from perspective of Polish business people who want to enter American market. Instead of making some kind of straightforward lecture, we will try to discuss certain issues from perspective of Polish business. And let's start with the first issue, in my opinion. So, assuming that we have a client who is interested in entering American market, establishing American business presence, and now we see the first question. So basically, from European perspective, we would assume that there is one common legal system for our country. Everywhere in Europe we work like this, maybe except for Switzerland. When we enter American market, then to our surprise, we see that actually there is 50 states, there is capital district, there is, I'm not speaking about Guam, Puerto Rico and other places, but there is at least 50 states. Every state has its own commercial register. Actually, every state has its own commercial code. And basically, we need to choose a particular state. Something like U.S. company formation, it does not exist. What is your advice for a person who says, we want to establish a business presence in the United States? Michael, please guide us. Where should we incorporate?
Well, first of all, let me just add to what you've already mentioned, and I'm not sure if all the audience is familiar with this, but the structure in the United States is on different levels. We have the federal level, which covers all of the country. And then, as you mentioned, we have 50 states, so that's the state level. And there's a system in the state level that's similar to the federal level. It parallels it. And then there can also be individual powiat or county level. There can also be municipal levels underneath that. So there's different levels of government, and there's different rules that apply. Sometimes there are rules about incorporating. Sometimes there are rules about doing business, checking whether certain terms can be used. For example, we have a case right now where the word institute was an issue, whether it could be used, and we had to address that. Everything depends upon the individual case. And the other thing I would add is that we loosely use the word incorporate, which refers to a corporation. I don't know what the proper word is for the other method we use called an LLC. I think Bożena can speak to that, but we do have corporations, we have LLCs, partnerships, sole proprietorships, different kinds of structures. So what does all this mean in response to your question? Like any good lawyer, it depends. It depends where you are and what you want to set up and what your purposes are. And as in the case of another client, they're incorporated as a corporation in one state, and they're allowed to do business in another state where they're actually operating. But the incorporation is in that first state. It doesn't mean they have a physical presence there. They have a legal presence as having been incorporated, but they're doing business in yet another state, New York. So we need to pay attention to the rules there. Let me turn to Božena for additional comments. I think she can give us greater insight.
Sure. Thank you, Michael. Yeah, so Michael is correct. The platform in the United States is such a lot of times entities will choose a place of incorporation, which may or may not have anything to do with the way they will operate, practically speaking, right? So one reason to incorporate in the state of Delaware, for example, would be because of the advantageous laws that protect corporations, shareholders, directors, and officers in the state of Delaware. So if a company is getting sued, or if the officers are getting sued, the most advantageous state continues to be the state of Delaware in the United States. It's very pro-corporation and pro-officer and director. There's other states where a company may choose to incorporate, for example, from a tax perspective. Nevada is one state. In the state of Nevada, there's no state income tax, so the companies don't have to pay state income tax there. So there are many reasons and many factors that will come into play in terms of why a company may choose to incorporate in the state. They may then decide to qualify to do business in many other states, right? Michael said one of them would be New York. We have companies and clients that do business in 35 states, 50 states, all 50 states. They will have to qualify if they satisfy certain criteria to do business in each particular state, and they do have tax and corporate responsibilities in those states. Taxes get prorated based on the amount of income that's earned from each state and things like that. So there are many factors that will come into play. But yeah, the first step generally is the state of incorporation that the companies pick. And then you go and pick your states where you do business going from there. One thing I wanted to mention, there is an equivalent, I believe, of a limited liability company in Europe, and I think it varies by country. I know in the UK it's the LTD. I think in Germany it's the GmbH and maybe an ASRL in France. I know those three off the top of my head. And those are the types of entities that we would associate closely with a limited liability company, which offers limited liability, and it's more suitable for smaller businesses. Although we have some very large limited liability companies in the U.S., mostly on the real estate market, but generally a smaller business would would form as an LLC or a limited liability partnership.
Okay, so let me stop you here. So first stage, we need to choose the state of incorporation. Then once we are incorporating the state, we apply local rules concerning way the corporation or LLC operates. So basically this is issue, what is the responsibility of directors? Is it possible to pierce the corporate veil and attack directors directly? What are bankruptcy laws and so on? So this we maneuver by choosing state of incorporation. And as Božena said, typical recommendation is Delaware. And I believe statistics say that more than 90% of public companies, they incorporate in Delaware for this reason. And then you will have this effect that the best judges, the best lawyers, they practice in Delaware. And there exists certain gap, Delaware and the rest of the country. Other issues might be tax issues. And if I understood Božena correctly, here the situation gets tricky because actually we cannot decide if we want to pay taxes where we make business. We need to pay taxes exactly in the state where we make business. So basically we can have situation that companies incorporated in one state, let's say Delaware, but we are doing business in New York or in San Francisco, we need to pay taxes also there. So we need to, for tax purposes, we need to be registered there. But this is totally separate issue from incorporation. Incorporation is only about commercial law. So this is the first step. Then another stage, and is something what Božena already mentioned, and I hope that she is able to tell us a little more on this topic, is issue what legal form. We know there are S corps, C corps, LLCs. I believe we can also establish a branch of foreign company, which is a little bit unusual, but I think is possible in the United States. What would you advise international clients, especially Polish clients, in terms of form of the company? What are basically the differences if all of these forms are suitable for foreign investors?
Yeah, so that's a really tricky question to answer because it really depends on um, it depends on a lot of different things, right? One of them would be how the business is going to be run, how the profits are going to flow through to the foreign owners, holders, shareholders, limitations that may be on the back end, meaning in Europe, right? Whether the entity is coming from England, from Poland, laws are going to be different. So that varies. But I'll just give you an overview of the main structures, and then we can go from there. Corporations obviously is the one, right? And corporations is um, um, similar to Polish spółka akcyjna, I believe, right?
Yes, yes.
Where you have shareholders. And in the United States, corporations are one major difference between a corporation and a limited liability company is that corporations are taxed twice, their income is taxed twice effectively. So there's a corporate tax at the corporation level at 21% federal rate, and we'll put aside the state rates for a moment. And then there is when profits of the company are distributed out to the shareholders get taxed on those profits again, right? They're called dividends. They're taxed at dividend rates. How that interplays internationally is that dividend, if that's distributed out to a European or a foreign shareholder, there will be treaty components, the tax treaty that will come into play, whether the dividend is taxed in the U.S., whether it's taxed in the foreign country, and the treaty will interplay with that. So we look at all those different things. Another type of a company that is very good to use here to run a business, a small business, or an investment company or a real estate business, is a limited liability company. A limited liability company provides very similar protections from a limited liability standpoint as a corporation, right? You mentioned that corporations have limited liability and they have a lot of protections for the officers, directors, and so forth. And that is very true. We have something called piercing the corporate veil. In other words, what's very, very kind of loose in terms of corporations here in the U.S. is that we have a system that says that an officer or director of the company can pretty much do anything they believe is in a good judgment of that officer for the company, as long as it's a benefit to the company, and he can justify that and it's reasonable. He would not be held personally liable for the decision he made, even if it turns out to be a bad decision, right? And I understand some laws in Europe can be quite different from that, right? There's really no personal liability for decisions that the officer makes in his capacity as an officer of the corporation, which is huge, right? Because otherwise nobody in the US, nobody here would want to take the responsibility and the risk of running a business, right? If you had to be personally liable for it. So it kind of promotes this decision making and ability to be free and to make decisions for the company, even if it's a bad decision, as long as it was not criminal, fraudulent, unreasonable, that individual will be protected. Right, and the limited liability company gives you a similar protection. It doesn't have that pierce the corporate veil concept, but the fact that it's called a limited liability company means in and of itself that under state law, that company will have limited liability. And so usually if the entity gets sued, that liability stays within the company and the company will pay the bill, will pick up the bill. Now, could an officer or a member of an LLC be sued personally in an individual capacity? Of course. Right. And 99% of the time, anybody that brings a lawsuit in the US, a very litigious society, we know that, will sue everybody and anybody they can. Right. But it does not mean that they will win the case against that person. It also does not mean that they will be personally liable, meaning the company a lot of times will pick up the bill, even if they are found to be in some capacity maybe liable personally in that lawsuit or settlement is reached with similar result. So those are the main structures. We have different kind of variations of that. Limited liability partnerships. We have something called the S corporation, which is also a pass-through entity, similar to an LLC. There's differences between LLCs and S corporations, mainly from a tax perspective and how compensation is treated. In one entity, it's deductible. You can pay yourself as an employee. With an LLC, you cannot be an employee if you're a member. So there's different variations on each, but the LLC and the S corporation are pass-through entities, meaning there's only one level of tax, right? So profits come into the company, those profits get distributed, and they get taxed at the individual level.
Okay, so basically, if I get it correct, it is once we choose the state, we are choosing type of corporation, type of let's say legal entity. First choice would be, as I understand, LLC, limited liability company, unless we want to go public, unless we want to have outside investors, unless we want to look very prestigious and credible to outside world, and then we will choose corporation. It's basically also the difference between spółka akcyjna and spółka z ograniczoną odpowiedzialnością in Polish law. Unless you are looking for something very particular and sophisticated, basically there is not too much difference, with only exception that corporation looks basically more prestigious. Plus, if you want to have outside investors, usually they tend to prefer the corporation structure.
Right. So yeah, that's a very good point. So C corporations are usually the preferred choice by institutional investors, and for these are fundraising and investor appeal, you would really choose a C corporation. That is correct. Right. LLCs offer more simplicity, more flexibility. But they're usually more geared towards different types of businesses. But C corps generally would be the preferred choice for and foreigners coming in with the goal of fundraising, raising money, investing. Yes, agreed, 100%.
Okay, so now Plus LLC will have a certain characteristic which I believe is already very interesting to Polish investors, because we see this going on. So there is a lot of people who are seeking to establish US company, not to establish actual business presence, also not to save money on taxes, but to have something what looks very prestigious in international trade. And for this, you will have LLC. Why? Because we have this rule that if LLC has only a single member and this LLC does not actually conduct business in the United States, then basically you don't pay any taxes in the United States. Bożena, if you could clarify if I'm understanding this well. Of course, LLC, we remember, is pass-through entity. So basically this tax does not disappear. It might still exist on level or shareholder. But this is other issue. My question is, if I understand well, that if there is single member LLC, we can have registered seat in New York, let's say, virtual address on Wall Street, but we don't do any business in the United States. Is it true that we don't need to pay any taxes in the United States? And what are actual reporting requirements for such single member LLC?
Right. So the LLC will still have reporting obligations. Whether it's one member or multiple member, right? It's still a pass-through entity. So it's not pass-through just because it has a single member. If it's a multi-member LLC, it's still treated as a pass-through entity. It's just a partnership because it has more than one partner, as opposed to what we call a disregarded entity if it has a single member. It still has reporting obligations here in the U.S. It still files a partnership tax return. We call it the 1065 at the federal level. There's an equivalent at the state level. But you're correct. The taxation will pass through to the individual members or partners, right? Whether that's one member, 2, 3, 4, 5, however the profits are allocated, those get distributed to the partners. Now, if the partner is purely operating out of Poland, out of England, out of France, they will not be subject to tax in the United States. Right, they will be filing a return. They'll be filing a return in Poland. However, there are rules that say, okay, if you're a foreign partner with a certain membership interest in a U.S. entity, you may still have an obligation in the U.S. So it depends on the particulars of a situation, right? They may have a filing obligation if they come into the U.S. and they're staying here, a certain number of days, exceeding the rules. They may be considered a resident. They may be considered exceeding that number of days where they would have an obligation here to file. Then that's when treaty provisions come into play, right? Where, then you have to look at, okay, well, where is he really operating out of? Is he really, operating out of Poland? Is he operating out of England? Is he operating out of the US? How many days and all that? So there's a lot of factors that will come to interplay with that. But the general rule would be that you're correct about is, yes, if you're a foreign investor just investing in an LLC here in the U.S., the taxation is passed through and the profits will flow through to that individual, and the individual will pay taxes, however appropriate, wherever the residency is, wherever they file.
Okay, so basically there is also a lot of things we need to clarify from Polish perspective. We see a lot of such LLCs here in business practice in Poland. So first of all, we have CFC rules, foreign controlled companies or foreign controlled entities rules. So from this perspective, not paying tax at all or paying suspiciously low taxes, lower than the 25% in comparison with Polish rules, this is not really advantage because you are immediately applying rules from CFC. So it might be better to choose corporation, pay 21% federal tax, and don't be CFC. This is like one scenario. Other scenario, if we say, we want to have this elegant company in the United States, but without business substance there is a question of effective place of management of the American company. Correct. Here in Poland, also almost everywhere in Europe, we have a lot of tax provisions which say what happens if a foreign company is effectively managed from Poland. And basically the consequence is that it should apply for tax identification number here in Poland and should be treated as a normal standard taxpayer here in Poland. So basically this setup looks very attractive. We can establish beautiful LLC, Wall Street address, looks prestigious, but might cause taxation here in Poland. It does not mean that the income taxes simply disappear. But I have one more question, because you mentioned this 21% federal tax, but unfortunately, US tax system is much more complicated because we have also federal tax. I believe we can have also, state tax. We will also have county level tax in some areas. So basically, once we are choosing which state to incorporate, we can choose states where there is no income tax. I don't want to lie, but I believe it's like Texas, Nevada,
Wyoming.
So Florida. Basically,
yep.
Yes, Florida. We can choose some which have low state tax. And until I believe it's something like 10 or 11% for New York and California. So basically those places where people incorporate anyway because they have business there and they don't have any other option than to pay taxes there. So if you could walk us through just a little bit, of course, how the taxation operates. Let's say we follow your advice, we establish Delaware LLC, but we really make a business, let's say branch office in New York. We rent their space. So what happens, office space? So what happens next, where we pay taxes, how this tax is in comparison with federal tax 21%?
So a foreign branch, so the 21% applies to U.S. corporations, right? So you have a U.S., when I say 21% corporate tax, we're talking about a corporation that is established in the United States, and the corporate level tax on their profits is 21%. That's the federal tax. That's a corporation established in the U.S. A branch that is a branch of a foreign company that is established there are two different things, right? So a branch is subject to something we call a branch profits tax. And when I think of a branch, and correct me if you're thinking something else, but when I think of a branch entity, I think of a branch of a foreign corporation. So there will be an entity that is a Polish company that establishes a branch in the United States, and that U.S. branch's earnings and profits that are considered effectively connected with a U.S. business. Remember, we have very complicated tax laws. So in order for your branch to be taxed in the first place, you have to have something called ECI, which is effectively connected income. And then you have to look at what's happening to those profits. Are they being shifted back to the foreign parent, or are they being reinvested in the branch? Because if they're being reinvested in the operations, they wouldn't be taxed at the 30% tax rate. So the rules get very detailed, right? But the general kind of basic rule will be that a branch is taxed at a 30% branch profits tax. So different from the 21% corporate rate, which applies to the U.S. corporations established here.
Okay, but if we do business locally in some state where there is a state tax, I understand would be that on top of this, we need to pay also a state tax.
Correct. If you're treated as having a business here, yes, there will be a state income tax, assuming you're in a state that has income tax. And for example, Delaware will not impose state income tax if you're not doing business in the state of Delaware. So New York will, right? New York is New York. New York has, like you said, a county tax and a city tax. I mean, there's so many municipal level taxes in the state of New York that, it probably goes beyond that. We can do a separate 2-hour seminar on that. But if you're incorporated in Delaware and you're not operating in Delaware, you wouldn't pay state income tax in Delaware. If you're incorporated in Florida, you're not going to have state income tax there. But yeah, that's the general rule. You're correct.
And on top of this, there is sales tax. I believe that in United States, you don't have anywhere VAT tax, but you have something what is more or less equivalent of VAT tax, that is sales tax. But also not in every state. So basically, in every state where we sell, we need to verify if there is a sales tax and then apply local rates and local regulations. Or is the sales tax uniform for whole United States?
Yeah, sales tax will vary by state. And then the rules regarding what's taxable and subject to sales tax will also vary by state. So, and then we have exemptions to the sales tax, right? Like if you come into the US and you're forming a construction company that's going to do stucco, that's going to put stucco on houses, right? I'm just going to give an example. And I go and I'm the company, and I go and buy my materials here in the US for my customer, right? I have a job and I'm going to go and buy materials, whether it's roofing, stucco material, whatever that is. When I go and buy that material, I'm going to use something called the sale for resale exemption. So now I'm not paying sales tax on that material because I'm going to resell it to my ultimate customer, and I'm going to charge the sales tax to the customer. And then I collect the sales tax, and I have a responsibility to remit that sales tax to the state authorities. So yeah, sales tax will vary by state. The services, the products that are taxable in each state will also vary by state. Now, they are similar, right? Most of them will model each other. So there's not going to be huge discrepancies. For example, if, most food is not subject to sales tax in New York, it's not going to be subject to sales tax in New Jersey. There will be some minimal discrepancies, but they're very similar. If, I don't know, even I'm trying to get an example. If a landscaping service is not subject to sales tax in New York, it probably won't be in New Jersey. But you still have to look because they do have differentials. But yeah, the sales tax definitely varies by state. Its application will vary by state. The exemptions will vary by state. So you have to be aware of all that.
Okay, thank you, Bożena, for this valuable insights. Michael, I have a question for you about the procedure of establishing a company, because it differs a lot from our European experience. First of all, in Poland, but generally speaking, most of European countries, establishing the company is a court matter. You will have a verdict saying that this company is formed. In United States, it is, I believe, just entry to a certain register. Then in Poland, you will have at some level and some moment of establishing the formation of a company, a notary involved, one way or another, usually drafting some kind of statute of a company of other corporate entity, because for foundations you will have the same. So basically, first of all, notary, which in Poland is a serious matter. This is like a public office of notary. It's not like just a person who is certifying signature. It's a government official. Then you will have a court, and basically the company is fully operational once the verdict of the court is final. And it seems that it does not remind too much American procedures of forming companies. Could you brief us on this, please?
You've actually touched on many things in your question comments that highlight the major contrast between the European way of doing things and the American way of doing things. We are not as formalistic in the United States. We are a very practical approach, and we don't have some of the traditions that have prevailed in Europe over the centuries. We don't have a notarius participating in any of this. I think that the people on the webinar may already be aware that we have something called a notary, but that's just a person who has a stamp and certifies that whoever signed the paper signed the paper. It's usually an assistant, a legal assistant, secretary, anybody, a lawyer, anybody can be a notary. You sign up, you pay a few dollars to the state, you get a rubber stamp, and you say, I saw the person sign. So we don't have this concept of the notary. The notary in Europe, I've always thought was probably an anachronism going back to the days when not everybody was literate. And I've participated in transactions in Europe where we are required to listen to the notary read the entire document.
It's normal procedure in Poland. Of
Normal
course,
in Poland, but we don't have anything like that in America. I always like to emphasize to our clients, and frequently our clients are European lawyers who use us as their special counsel when they're doing something for their Polish client in the United States. They don't just turn it over to us. We help them and we keep them involved. And it often requires explaining that we have some major differences. As you point out, Robert, we have a very practical approach. We fill out some papers. We file them wherever we need to file them. But almost everything has nothing to do with the state authorities. It's done by the corporation. An example, recently we had a client wanting to pass a resolution, a board of directors resolution, and they said, well, when do you file this, and how much does it cost to file it, and where do you file it? And we say, well, you can file it in a drawer in your office because we don't file it with the state. They're not interested to see any of that.
So basically it was a Polish client, probably was a Polish client, because we need to file a lot of resolutions we need to file with authorities, yes.
And
yeah,
we
don't file any. These are all internal documents. We get that question a lot from foreign investors. The rules are much more relaxed here in the US. We don't file any resolutions. The bylaws are not filed. They're all internal. They can be amended as many times as one wants. So it's very different.
Yet corporate documents are normally those documents which you filed. They are very standard. Why we tend to draft them, customize them for our clients. You will have certain drafts of articles of association. Of course, you can change something, but this is not something you normally do. You don't change. So as I understand, apart from those standards, you will have, or you might have, some kind of agreement between shareholders, which will be a private agreement. And this is like the real thing, the real document which regulates how the company operates. Is my understanding, Michael, correct?
Yeah, I think it's correct. We want to make sure that we emphasize the practical approach that we use in corporate law in the United States, and that there's a general attitude. I sometimes talk about this with clients. There's an attitude that I perceive in Europe and also in Israel that's very, very formalistic, and there is kind of a built-in assumption that there must be suspicion of wrongdoing. You have to check everything. You have to be suspicious about everything. The United States is kind of the reverse. We know there are people who do things that aren't right, but for the most part, we approach business assuming everybody is honest and open. And this leads to this informality. Now, of course, sometimes there's a problem, and we can talk about that too, where things aren't quite right. And I don't mean necessarily on the criminal side. There's also on the civil side. I'd like to go back for a moment to something you brought up before in your comments, Robert, when you spoke, and also Bożena spoke about piercing the corporate veil. And I don't know if you use the term alter ego, but I would say those two go together. And the people who are watching on the webinar may already be aware, but one of the reasons we create a corporation or we create an LLC is to make sure that we've created an independent body, an independent institution that is separate from the owners and separate from its board and its officers in terms of liability. So in some countries, if a business becomes insolvent, there is personal liability on the part of management, even criminal liability, for bringing the company under its supervision into a state of insolvency. We don't have things like that in the United States, but we do have occasions when people who own a company, especially a small company, not a big one, people who own a smaller size company must be careful when dealing with the payments that are made, that they are keeping separate the checkbook, so to speak. We don't have checkbooks in Europe, but the payments that a company makes should be for the company's debts, and never should it be for the personal debts of the officers and directors or shareholders. And I'll give one example to illustrate that. We had a case once. We do a lot of insolvency work at Cullen and Dykman as well. We're a full service firm, so we have corporate, we have tax, we have insolvency and employment, many areas. We had a case where a lumber company wrote a letter to its customers. The lumber company said, "We are insolvent, we can't pay our debts, we're going to liquidate." And several of the larger creditors approached us to investigate. And we did investigate using the laws that are available, depositions, which also don't exist in Europe, but a way of questioning and looking at the books and records. And we found in the company's checkbook, its payments, that there were payments to a landscaper when the company's building didn't have any landscaping needs. And we see that the payments resulted from an work order, to treat the landscaping of the owner's personal residence. Now that's piercing the corporate veil. That means that the owner used assets of the company to pay its personal debts. What that means is that we could look to the assets, eventually, we could look to the assets of the owner, because he treated the company pocketbook much like it was his own. So that's something very much to keep in mind when advising clients who are setting up business in the States, that that's a danger that should be avoided by keeping the corporate integrity separate from that of the owners, or for that matter, the officers and directors.
Okay, so let me just rephrase it, because it sounds so shocking for European customers, clients, that I need to double check if I understand you right. So basically, we don't have legal obligation to file for bankruptcy. It is our right. It helps us to divide assets, but it's not that directors will become automatically liable for debts of the company if they don't file. Because basically, the idea that directors are immediately responsible for debts of the company if they don't file for bankruptcy is a basis of European, especially Polish responsibility system. So I understand in the United States, filing for bankruptcy is our right, which helps us to deal with too many creditors and distress situation, not our obligation. And certainly we don't go to jail because we didn't file for bankruptcy, is that we are staying with the problem of too many debts.
It's very good you said that, and I do want to clarify it. There is no concept in the United States that a officer or director must file for bankruptcy, not in any criminal sense. However, there are cases that we've had where people who ran a company into insolvency did so not maliciously, but negligently. They made poor decisions, and they shouldn't have gotten the company into that bad situation. So what we do is we sue them civilly for negligence. But in almost all cases, there is an insurance policy. we always advise clients to have director and officer liability insurance. So if there is a negligence, a failure to do what they should have done, if they were being reasonable, we can actually sue the insurance company for whatever coverage the director has. But to do that, you have to prove that they fell below a certain standard of performance. You have to show that they failed to behave, to act as a reasonably prudent person in similar circumstances would. That's kind of rare, and those types of cases, by the way, almost always get settled. But distinguish that from criminal liability. There isn't criminal liability for simply being a bad or negligent manager, unless there's something more that would constitute malfeasance, in what we would say malfeasance rather than misfeasance. There are cases where people intentionally do things that are criminal, but then they get charged by the state under criminal law for whatever it is that they did, for the crime of embezzlement or larceny or whatever. But in the case of civil law, yes, you can go after them for negligence if you can prove it. Otherwise, there's a separation between the people and the company, so that when the purchasing agent for a company orders some goods and those goods are shipped, and then there is a failure to pay, the purchasing agent is not liable. It's the company that's liable, unless you pierce the corporate veil and say that the purchasing agent and the company were one and the same because he or she treated the assets of the company as though they were her own.
Okay, thank you for this important clarification. Okay. Bożena, I have other question, a little bit like, seems to be small issue, but in practice it is a great deal. I mean, opening a bank account. For a long time, it was just a technical issue related to company formation. Nowadays, due to AML procedures, KYC procedures, I see that establishing a banking relationship in the United States starts to be a problem, almost like with opening account in Switzerland. So basically, it is a game of chance if bank will accept a client. Sometimes those decisions, they are very surprising also to me, what is expected from the client. Then what we noticed, and I believe it was even subject of an article in New York Times, we have this situation that bank just send termination notice without any explanation. Sometimes just after opening a bank account in random situations, they refuse to clarify something. Do you have any practical tips how we should approach the issue of establishing a banking relationship in the United States?
Yeah, and I'll let Michael speak to that, because actually he has been dealing with this issue more recently, but it has become more difficult. From a practical standpoint, it is the bank asks for something called a taxpayer identification number. And the reason is, if there is, most times the reason is they want to be able to identify that person by a number that's a U.S. number. So if that person comes in, opens a bank account, whether it's for a corporation or for themselves, and there is any kind of, and funds are being put into that bank account that grow, let's say, interest, right? The bank has reporting obligations and withholding obligations on that interest, especially to foreigners. So without that TIN number, that taxpayer ID number, they're in a bind, because see, the way the laws work in the US is, and this is one of the reasons why it's become more difficult, is if the company or the bank has a withholding obligation to withhold a certain amount of tax, and they don't, they become responsible for the payment of that tax. That liability becomes theirs. Okay, so if I'm a withholding agent for the Internal Revenue Service and I have to withhold 30%, at 30%, tax on dividends that are being shipped out to a foreign investor in Poland, and I don't have a TIN number, I can't do that withholding. I'm going to be on the hook as the bank for that money. So that's one of the reasons why it's become more difficult. It's a reporting issue that the banks have been running into. I'll let Michael speak to that from a practical standpoint, because we've been trying to get over the hoops of trying to form a bank account for someone that does not have a TIN, and then to try to apply for a TIN. It's a process that takes weeks, right? And we have clients that come in and say, hey, I want to open up a bank account tomorrow. How can I do that? And that's where the problem is.
Someday soon, I hope we should do this discussion using Zoom instead of webinar, because I'd love to see the faces of the people who are listening and how they are reacting to this. But let me say first a general comment, then I'll be more specific. In my view, there is no question but that the political situation, security situation around the world has impacted the banking relationship tremendously in ways that it never did before. And if I had to come up with two reasons, I would say terrorism and drugs are making banks live under an extremely more serious regime than ever before. And they are very worried about participating in any transactions that might be covered by various laws in the United States and other countries with regard to trafficking in drugs or in terrorism. That's why they've become less the old American style of being informal, roll up your sleeves, get it done. They're being much more careful and formal now because of that. I hope someday soon that will all change, but I doubt it will for a very long time, if ever. So what does it mean? Well, when we had a client come to us from Poland a while back, they wanted to open up in the United States, and we said to them, okay, you'll need a bank. And they said, can you recommend a bank? And then we gave them a list of all the usual banks, and we suggested that they talk with them all. But we recommended in particular a bank that we have used with other clients and who does work with us as well, that we do some of their legal work. And why? Because as a practical matter, we had a relationship on a person-to-person basis. The same people that we be dealing with on a formal basis also come to our firm Christmas party. We also talk to them socially at receptions. It's the person-to-person contact that makes all the difference. And indeed, recently, we had a change of management for that company, and it required things to be done regarding signer authority, signatures. We had to do some exceptional things because of the press of time that a strict reading of the rules might not have provided a way out of it. But because we knew the people and we could trust one another, they relied upon our word on behalf of the client for a few days, and we got the job done. And we were very glad we picked a bank that was so cooperative with us, sticking to their rules, making sure all their protocols were honored, but at the same time, having a flexible view of how to get us to the goal. So the company comes to the USA. They need to have a bank, pick a bank. They open up an account. They will probably want to have one account for spending, another account to keep most of their money in that they can feed the spending account. And they may also have a long-term account, like what we call a certificate of deposit, that stays in one place for a longer period of time and earns a higher level of interest. So those three types of accounts are likely. Most all banking is being done through electronics. Now, that's no surprise to you guys in Europe because that's normal. But in the United States, even now, people use checks, and some people use cash even. But mostly we're seeing the evolution in the United States so that you can take care of your banking. And then the other part, practically speaking, again, for those that are actually going to come over here and do something, you got to get a good accounting firm. Your accounting firm can take care of supervising to make sure that everything's been checked and double checked and that the payments are being handled properly and authorized properly. And plus, they can fill out your tax returns. It's good to have an accounting company that's reputable and reliable. Accounting firms don't just push numbers, though. They also have other practices like they do in Europe. Some accounting firms have legal departments. We don't quite have that, with one exception of a firm that started to do it now. But mostly accounting firms turn to the law side to handle things like employment law, rather than using their own human resources department. But the banking, yes, you're absolutely right, Robert. It's an important part of setting up here. And one of the things we do at Cullen and Dykman is just give this practical guidance and tell people, give people the benefit of what we know, doing it the American style.
Okay, thank you for this answer. I believe we have less than 10 minutes to end of our webinar. So I have a question. If we have any questions from my audience, if yes, maybe we can transmit them. If not, I still have few points to clarify with Michael and Bożena, so it's all up to listeners. Do we have any questions?
Not now, but we can ask the participants.
Okay, if any participants they have questions, please send them on chat. I believe it will be the most practical way. Because we still don't have any question, I have practical question, which maybe shows a little bit how much Polish clients they are lost with American system and they don't have slightest idea what to do. Question: how I know that I own my own company? And I will explain the background of the question. Here in Poland, we will have an entry in a court system saying that you, Mr. Robert Nogacki, you own 90% of this company. It will be filed with authorities, will be a court decision saying that we are accepting this, and then you go to authorities. Actually, everyone can do this, not only the company, generate so-called odpis Krajowego Rejestru Sądowego, excerpt from the commercial register, and then you see official document saying, I own certain stake in this company. And in the United States, I believe we are operating on basis of certificates of membership in LLCs and certificates of shares. So basically, first of all, nobody from outside knows who owns LLC or corporation. Secondly, what really happens, how we can verify from two perspectives, from outside, with who I'm dealing, because I need some document to make sure that I'm dealing actually with the right person to represent company. And from the perspective of owner of company, how I know that I really own this corporation? What is the document certifying that actually I'm the owner if I don't file anything with authorities?
Right. So that is a very interesting question that we had to deal with, actually, Michael and I, with a Polish client of ours. Interestingly, there's unless it's a public company in the U.S., public corporation, there will be nothing except a contract, a document that shows that you put in $1 million to get 30% of that limited liability company. You invested $1 million. And in return, you become a 30% member, right? And your name is in the membership agreement, and there will be an exhibit at the end of that membership agreement that will say that you own 30% of the company. There are certificates. We will issue a certificate. There is that. When I say nothing, I don't mean nothing. I mean there's a certificate that will be issued. It could be a stock certificate for a corporation that will show a certain number of shares owned by that shareholder, or it will be a certificate equivalent for a limited liability company that will show the number of units. We call them units in LLCs, that will show that you own a certain number of units, right? Let's say there's 100 units. A third will give you 33% or 33.3 units. That doesn't get filed anywhere, though, right? That's the trick, right? And like what you just said, in Poland, it gets filed and there's a record of it. Here, it doesn't get filed anywhere. It's just a document that you get. You can request. You don't have to. You get it, and then you have it. If there's a breach of that contract, or if somebody later tries to come in and say, well, no, you don't own that company, well, you do have proof of your investment capital, right? How much you committed in capital to that company. You will have proof of that, and you will have that document that initially will show. If you have a good lawyer, that lawyer will tell you, go get that certificate that shows your units or your shares and keep it in your records. And there will also be a shareholder agreement or a limited liability company agreement evidencing the ownership percentages of the individual members. As the company continues to operate, one way to show ownership is through distributions to that shareholder or a member. either from the corporation or from the limited liability company of the profits of the company, right? So if I'm a member of 33% and I'm getting distributions of 30% of the profits, it's not easy for somebody to come in and say, you're not really the owner, because I wouldn't be getting distributions if there was distributions being made if I was not the owner. So there's ways to prove it, but there's nothing that's going to be formally legally filed with the state, nothing that's formally legally filed with the county, with any court. It does show up in the tax returns, though. And remember that the corporations have filing obligations that if it's a public corporation, it will tell you exactly, they'll file public, returns that informational returns that show how many shareholders they have. That's, that all that. If you're a private company, the informational returns that are filed, let's say at the LLC level, will show the members and it shows their percentage ownership. So there's ways to prove it, but it's not a formally filed, court document / decision that's anywhere in the entered into the court system or any kind of county or state system.
And what the very last question, because we're running out of the time, but this is actual question which I get a lot. What if my certificate get lost or get destroyed? Is my ownership lost, or is some way? I know it's a serious question. Actually, it has certain legal reasoning. For example, we have this kind of document like Wexel in the Polish law, which is a security. And you actually cannot do nothing. If you lose the Wexel, then you will not have court case from the Wexel. You still can have some legal claim, but you will never prove that you had a Wexel by witnesses, other documents, indirectly. So there is a concern from our clients, a question. If everything is proven by this tiny piece of paper called share certificate, what happens if I lose the share certificate? What is the procedure then?
You ask for another one, they will reissue one to you.
It's good answer, but bad in the same time, because for this I get other answer. So basically they are issuing the certificates like this, and then the people are still concerned. So what is the trick here? Is company able to issue those whatever they want?
Well, it's not, so if I own 1,000 shares in a company that were issued to me on a particular date, and I lose my certificate, right? The company will reissue me that certificate with the exact the same details, showing the exact same transaction. It will still relate back to the original date of issuance. It will not have a new date of issuance such that you can cheat where you say, oh, well, I got 1,000 shares back then and I have 1,000 shares now. It's going to still say date of issuance was, January 1, 2020, and you received 1,000 shares. And in the company ledger, it will be listed, that was the only issuance to that particular shareholder. So there is ways that companies keep track of all that. And when you reissue a certificate because it was lost, you just kind of put that in your ledger and say, okay, certificate was reissued. And then remember, the certificates are numbered, right? So that there's ways to keep track of all this. So it's not that easy to cheat the system. If you lose it, I mean, you're still an owner. I mean, I'll give you a funny example, actually. So recently I was dealing with a client. One of the members of the limited liability company had passed away. And the beneficiaries, right, the kids are coming and saying, well, we want the company, we want 30% of the profits, or we want to sell it, whatever the case might be, or they want to be bought out of that 30%. There is nothing showing that this guy owns the 30%, right? And we said, well, where's the membership agreement? And there isn't one. They couldn't even find the limited liability company agreement. Okay, so take that, but that's an interesting situation, right? But there's ways to track it that show that, yeah, he did invest a certain amount of money. This was the original percentage of the company he got. And then you have to worry about trying to figure out if there was any adjustments, if there was any, it can take, I'm going to give you credit because I think your way is a very efficient way of keeping track of who owns what and how much. And sometimes we get into situations where we have to take a long time to try to solve them. But like if you don't have a shareholders agreement, and then there's the issue of even forget the ownership percentages, but who is in charge of making decisions if there's not a shareholders agreement or a limited liability company agreement evidencing the management, right? So in our firm, we have a practice of very clearly telling our clients what to do, how to do it, and setting forth the law and the guidance that they need to be able to run this efficiently. but can the certificates get lost and could you run into legal issues? Of course. But yeah, there's not a formal process. You do get a certificate. You don't have to have one. Like, the companies are not required to issue you one. You can request one. It's available at your option, and it is in a company ledger. So, yeah.
Okay, sorry to cut the conversation. Actually, in the moment when it started to be really interesting, but we are running out of the time. So, Bożena, Michael, I want to thank you very much for your participation. Again, Bożena Diaz, Michael Tryson, Cullen & Dykman Law Firm from United States. Thank you very much. And we will send to our participants materials after we finish the webinar. So thank you very much. Good afternoon.
Thank you.
You're welcome.
Bye-bye.